as Terri mentioned a little bit earlier, I know we had a couple of late joiners as well. This is Terri Macklin. She is the supervising attorney in our probate and trust administration department. My name's Heather Swiklinski, and I am the supervisor of our department, kind of oversee the whole process for both administration of trusts and probate. We also handle guardianship and conservatorship in our department as well. So the main purpose for this workshop today is just to give you an idea of what the process looks like when we actually administer a trust or have to open probate after somebody has passed away. So this is what the process looks like for the beneficiaries who are involved and for those who are in charge of administering the trust. In this case, that's a trustee, or in the event of going to probate, that's a personal representative of the estate. So what a lot of people wonder right off the bat is, what should your first steps be when somebody has passed away? So before you worry about contacting us, those first steps are going to be notifying family, securing their property. So this pertains to real estate, vehicles, accounts, just getting access to that property and securing it. Looking for legal documents. So for most of our clients, you're looking for a binder. We put our estate planning documents, such as the trust, powers of attorney and will, and a binder. So that's what you're going to be looking for. Making funeral arrangements. And one of the things that is handled during that process is the funeral home will issue a death certificate for the person who's passed away. And once you have made it all the way through step 4, you have that death certificate in hand, that's the time to contact us to go forward with the next steps for either administering the decedent's trust or looking at opening probate for any non-trust assets that they had when they passed away. So, are you a beneficiary? A beneficiary is either a person or an entity who's entitled to receive money or other benefits upon the death of a benefactor. So there's different types of beneficiaries. You might be a beneficiary of what's called a specific bequest. So that is a specific gift that's outlined either in a trust or a will. That could be a piece of property, an item, or a certain amount of cash. You could be a residuary beneficiary, and that means that you receive a certain portion of the trust property after any specific bequests have been satisfied. Usually this is a percentage. And you could be a contingent beneficiary, and that would just mean that you're only a beneficiary if somebody else maybe predeceased the person whose trust it is.
Question. This might be a simple question, but how much of this is applicable if, my wife and I, if one of us die, does anyone have to go through any of this, or just sit and wait until we're both trustees, both gone?
So the majority of the time, it usually waits until both grantors of a trust have passed. There are some different circumstances. Sometimes blended families will have semi-separate estate plans for husband and wife, where, upon the passing of one, some of their property might get distributed early. But in most circumstances, yes, it would wait until both grantors have passed. All right, so we're going to be talking about trust administration and probate. So first, we're going to touch on what happens when somebody has passed away, where the majority of their assets are held in a trust. A trust is an agreement in which one party holds and manages property for the benefit of another in order to avoid probate and protect assets for the future. A trustee is the person who's responsible for handling the assets held by the trust and following the terms of the trust. So if you have your own trust, odds are you're also your own trustee while you're still alive. You also have what's called successor trustees named in your trust, and those are the individuals who are going to be administering your trust after your passing. So the timeline for trust administration looks very similar in most instances. We always start off by notifying all of the trust beneficiaries of the passing of the grantor and letting them know what they can expect from the process. So it is Michigan law that we have to notify every beneficiary that they are a beneficiary. They're entitled to the sections of the trust that pertain to them. So what that means is it's really up to the trustee whether or not they decide to release the entire trust document to a beneficiary. They do have to give them the sections of the trust that directly pertain to them, but don't necessarily need to provide the whole document. The trustee has a duty to make every effort to locate all beneficiaries. Usually that's not a big deal. It's usually close family. Oftentimes, if we don't have addresses, we're able to look them up. Or if we have, the rare case of an MIA beneficiary, there are companies that can help assist us in locating them, air search companies. The next step is to publish a notice to creditors. So if we are retained to handle a full trust administration, we would handle publishing that notice in the newspaper. Creditors have 4 months after the date of that publication within which to file a claim against the estate. After that 4-month period, all claims are barred. In the case of trusts, not all creditors who make claims are guaranteed to get a payment. That's one of the benefits of a trust. It offers that protection. Essentially, every bill that we get from a creditor, we respond to them, letting them know that they need to file a claim. And then if they file a claim, we disallow it. And yes.
What happens if mom's in a nursing home and on Medicaid?
Mm-hmm.
Then are they one of the people that have to be notified?
A nursing home?
Yeah.
If they have outstanding bills from a nursing home after they've passed away, is that what you're asking?
Yeah, well, she's on Medicaid and one of your protection plans.
Okay. So one thing that's a little bit different with Medicaid is sometimes Medicaid does have an estate recovery that takes place after somebody has passed away. And that is one of the few creditors that we do recommend paying. So it just kind of depends, when that time comes. If somebody passes away with a trust, most of their assets are funded into that trust. So even if they are on Medicaid, when they fill out a questionnaire asking what assets they had at the time of their death. So for example, if they had a house, but the house is in a trust, they would just say that they didn't have a house because it's not in their name.
Oh.
Does that make sense?
And if I could add to that,
sure.
Heather mentioned that's one of the creditors we sometimes recommend paying. Nursing homes, if they haven't been paid, like if someone's in a nursing home and they're private paying, let's say, and they have a bill, they tend to be more aggressive as a creditor, and they will sometimes sue to try and enforce that. But with estate recovery is if you were in a nursing home on Medicaid, when that person dies, the state of Michigan can file a claim in the probate estate to get reimbursed. The state of Michigan cannot pursue the trust assets, only probate. And so it's really important, like we do these trusts and the protection trust, that there is nothing going through probate at the time that person dies, because those state of Michigan claims, they can be 300, 400,000. So we look at that. We will advise you if we think that there's a creditor out there, like a nursing home, that probably is going to need to be paid. Otherwise, they're going to sue. But we try to negotiate with them and get that payment down.
Mm-hmm.
So,
yes.
Sure. I apologize. So while somebody is still living, I'm an executive. If they are requesting copies of the trust,
mm-hmm.
I do not necessarily have to provide that to anybody.
No.
Okay. They may
Correct.
need it, but they don't have the right to see it.
Right. And are you talking about your own trust or your mom's? Yep. So if you're the trustee for her, until she passes, only at that point do you have to provide a copy. And even then, like I said, it doesn't have to be a full copy, just the sections that pertain directly to them. I will say, though, if you don't have an issue releasing a full copy, that's usually the way to go, because otherwise people get paranoid. Yeah. All right. Oh, yes.
If there's no debt except for like credit cards, do you still have to publish that thing in the paper?
That's our recommendation, mostly because it limits that creditor period to 4 months. Otherwise, it's 6 years. 3 years. 3 years. So I think for peace of mind alone, that's one of the driving factors behind that. We always do it as part of our process, definitely. Yep.
It's required by law to do it. You have to give notice to creditor. If you don't, it's just 3 years. So the law says to do it. So you should do it. Unless you want to break the law. It doesn't matter.
But that way you're covered because you.
Exactly. And that way, after that,
way they have to make a claim.
yes.
And you could fight any false claims.
Yes. Yep. And even if they have a legitimate claim, if your assets are all funded into your trust, you can disallow that claim. And they always have the option of filing a lawsuit. We personally haven't seen it. Only with the nursing home, but credit card bills, other medical bills, stuff like that.
If you could, when you answer a question, can you repeat the question?
Yes. Yes. Sorry. Okay. Any other questions about the creditors process? Yes.
If you use money on your home still, how does that?
Sure. So the question was, if you owe money on your home still, how does that get handled? So if you pass away and you still have an outstanding mortgage on your home, typically the plan is to, during the process, sell the home, liquidate it. And at that time, the remaining mortgage would get paid off through that sale. And only the net would go into the trust after the home had been sold.
What happens if you gave somebody rights to live there until they pass? Then what?
Question is, if you give somebody rights to live in the home until they pass, what happens with the mortgage? They would either have to assume the mortgage or relinquish their right to live in the home and sell the property.
Yeah, Heather, if you could just repeat it, the mortgage company is going to have priority.
Mm-hmm.
So, and a lot of the mortgages, especially if you have a reverse mortgage, the reverse mortgages especially will say when the person dies, it's defaulted basically, and it comes due at that point. But otherwise, if you gave somebody the right to live there, if they weren't part of that with the mortgage and everything, the mortgage company can come in and trump that if they're not being paid.
Mm-hmm. And we have seen complications too with people trying to assume mortgages. It's a little bit more difficult than one would think to take those over.
Most mortgages are not assumed. They used to be a long time ago, but now they are not.
All right. So next step in the administration of a trust is to determine a trust inventory. So one of the requirements of the trustee is to determine all of the assets that are in the trust. So this is typically going to be bank accounts, investment accounts, life insurance policies, real property, any accounts that name the trust as a beneficiary. So here's some examples. We work together with the trustee to put together a list of all of those assets and determine the value of each asset as of the date that the individual passed away. And this is information that we provide to all of the beneficiaries. That way, everybody is in the loop. They know exactly what was in the trust at the time of the grantor's passing. And by the end of the process, they'll be able to see everything that came into the trust and everything that went out of the trust during the process, and how we got to our final trust value and balance at the end.
Not personal property, just the things that were in the trust.
Yes. Personal property, so things like furniture, clothing, cars, anything that can't be titled into a trust, that's handled a little bit differently. Usually that's also the responsibility of the trustee to either sell it or divide it up amongst the beneficiaries. Usually we recommend that the trustee gives everybody an opportunity, to come to the house, meet and, take turns selecting property that each person wants. We don't typically run into a lot of issues with the tangible property, but one thing that is beneficial, if you have your own trust or your own will, to keep kind of a running list of items. If you have specific things that you want specific people to take, it helps if the trustee has a guide for how to distribute those. Vehicles are a little bit different because those do need to be transferred, obviously, out of the decedent's name into somebody else's name. So depending on what the goal is for those vehicles, if they're all getting sold, usually what happens is the trustee is able to transfer the title of those vehicles into their own name through the Secretary of State, sell them, and collect all of that money and put it into the trust account. That way it can be split up amongst the trust beneficiaries as well. Or if they come to some sort of agreement where a beneficiary is taking one of the vehicles as part of what they're receiving, they can handle transferring it into the beneficiary's name, also through the Secretary of State. Did you have a question?
I do. If there are some assets outside of the trust that might have some value, significant issue, we'll see, let's say items like jewelry and things. So if there is that disposition of assets, as you said, to family members, is it wise to get those things evaluated prior to, because that all goes into the conflict for the division?
Yes. So the question was whether or not it's beneficial to have an appraisal done on certain types of tangible personal property, specifically jewelry. We do recommend, just as a general rule of thumb, for anything that's value is, give or take over $1,000. Particularly if there is any discourse between beneficiaries, it's a good idea to get things appraised. That way, if somebody's taking a piece of jewelry that's worth, $10,000, you'll probably want to reduce their share of cash by that amount to keep things fair between everybody. So, that's not always going to be the case. If something is just of sentimental value, might not need to take that into account. But yes, for stuff like jewelry, some guns, instruments, those sorts of things can be a little bit more pricey. Yes.
If I have children named, as beneficiaries for the item, all of the value of the estate, but I want one particular child to have all my personal possessions. I just wrote out a page in my trust that said that I want all my personal possessions, including my vehicles or anything like that, to go to that person.
Yep.
That should not affect their share of the.
As long as it specifically states that in addition to their residuary share that they are to get all of this tangible personal property, then no, it wouldn't impact that.
It's just on a page they gave me in the book that I wrote it in. Does it have to be included, that language, into the estate?
So it kind of depends. I'm thinking about our trusts in particular. Our trusts have a section that specifically refers to the tangible personal property. Yep. So, most of the time it'll just say equally to our children. If you want it all to go to one person, that's where it would show up there. And it would be the trustee's fiduciary duty to make sure that they follow what the trust says.
Well, it's the same as the trustee.
Okay. Yep. Well, that makes it easier then too. If the person to receive all that is also the trustee.
But that should not affect that child's portion of the divided estate.
No, nope. Especially if you're directing that they get all of that. The only time it might impact it is, what we see most frequently is that the trust directs that the children split it all evenly. And in the event of something that's worth a lot more than the rest of the property, that could potentially impact their distribution. Yep. Any other questions about that? Okay. All right. So once we have an inventory put together of what's in the trust, we start liquidating everything that's in that. So we will get a tax ID number for each trust and then establish a new trust bank account. The idea is that as we're cashing out accounts, cashing out life insurance policies, selling property, all of that cash will be consolidated into this new trust bank account. The goal being a full consolidation, all the monies end up in that account, and that account is where we have our final balance, and that is where final distributions are calculated from at the end of the process. So while we are in the process of liquidating everything and consolidating it, we are also keeping a running accounting for the trust. So like I mentioned before, one of the requirements of the trustee is to provide each beneficiary with a trust accounting. So they need to show what the inventory of the trust was at the time of the grantor's passing, and then show all the transactions into and out of that trust account. So you're going to be seeing where they're depositing, for instance, payouts from life insurance policies, refund checks that they might receive for the person who passed away, consolidating maybe checking and savings accounts that they closed, moved into this new trust account. Some withdrawals you might see is, for instance, if there's still real property, they need to keep the payments up on the utilities and the insurance and that sort of thing until the house sells. So those are some expenses of the trust that can be paid out of that trust account. So examples of income, interest, refund checks, life insurance payouts, funeral costs are an expense of the trust that can be paid out of there. And then again, insurance and utilities for the home. Our trusts have several distribution options built into them. So one of them, and the most common, is what's called a separate share trust. So each beneficiary has an option, at least in our trusts. If you have a trust with a different attorney, this might not be an option that's built into the trust. But the option to establish what's called a separate share trust for their inheritance. And what that looks like is we get a separate tax ID number for their separate share trust, and we walk them through the opening of a new account that can be a checking account or an inheritance or investment account, excuse me. And that account holds their inheritance. The benefit of the separate share trust is that your inheritance is 100% off the table for creditors. And it also doesn't count against you if you need to be approved for Medicaid later on down the road. Also off the table in the event of divorce. So this is beneficial also for if you have a beneficiary who is receiving any sort of government income-based benefits, where they might otherwise get kicked off of those benefits if they were to receive an inheritance that put them over that income limit. This is a good option for them for receiving their inheritance. Yes.
Is that also appropriate for somebody that's not the same thing as a trust for like a special needs trust?
Yep. So this is a little bit different. Yep. The question was whether this was the same or different than a special needs or supplemental needs trust. This is different. So this still gives the beneficiary control of their money. You have to have a co-trustee. Most people choose a spouse or a child or just somebody close with them that you name on that account. But by having that co-trustee and by having that run under a separate tax ID number, it doesn't touch your social security number, won't impact your benefits if you're collecting any of those, and off the table for creditors.
So what happens if some of those separate accounts are going into, like, say, a child's name? So the way our trust is set up is our grandchildren get 60% and the two daughters get 40%.
Okay. So are you a grandchild trust or directly to the grandchildren as an individual?
We have it put in separate accounts.
Mm-hmm.
So we have 6 grandchildren. So with each one of them get a separate account.
Yes.
And then who would control that account? The trustee?
Yep. So usually when it comes to minors, there's some language in there that states that up until I think it's age 25, it is typically the parent who's in charge of that. And then upon the age of 25, and don't quote me, this is different from trust to trust, they can appoint their own co-trustee either at 25 or 30, but it's all the same benefits, work similarly. But for minors and those under 25, it's usually the parent who's in charge. Yep. And it kind of depends on the amount of money that they're inheriting. So if somebody's getting, only 5,000 or 10,000, it might not make sense to necessarily go through the channels of setting up this trust. Usually we say like 25,000 or more, but it can be set up for any amount. Yes.
With a separate shared trust, when does that actually spring? I mean, is there other things that have to happen before that trust can go into effect?
So setting up the trust itself is a matter of signing certificates of trust existence, getting that tax ID number, setting up the account. So it doesn't come into existence until those documents are signed and the tax ID number is assigned. Usually it's something we just kind of wait until the end of the process to do when we get closer to the point of making distributions, and give everybody those options. Yes.
So hypothetically, 2 grandchildren, my son, and there's the prior daughter-in-law now divorced.
Mm-hmm.
I certainly don't want that parent of those grandchildren, that parent, the divorced parent, the divorced daughter-in-law, to have any access to those funds. How is that handled? Just have the main parent in the trust?
Yes. So most of our trusts anyway state that the trustee of a separate share trust should be whoever is named as the general trustee. So typically it's going to be whoever's already laid out in your lineup for successor trustees.
Thank you.
Yes, you're welcome. All right. So the next option is that supplemental needs trust. This works very similarly to that separate share trust. The main difference is it is not controlled by the beneficiary. So rather than having co-trustees where one is the beneficiary and the other is another individual that the beneficiary selects, the supplemental needs trust option provides that typically the general trustee is the trustee for the supplemental needs trust, unless the trust specifies otherwise. And this is beneficial for anybody who maybe doesn't have the best money management skills, or, isn't able to make their own decisions about their money, that sort of thing. If you have any concerns about, I've seen where we have, grandchildren that have substance abuse issues or just challenges in life and they need some guidance with their inheritance, this is a good option for them. So it has the same benefits as that separate share trust. It runs under a separate tax ID number. It doesn't touch the beneficiary social security number. It has that added asset protection. Again, generally for disabled beneficiaries, and falling under that disabled category, we also include anybody who we deem to be incompetent in terms of managing their money. The other option that is not on this is to just receive the inheritance outright and free from trust. So nobody is forced into choosing either a separate share trust or a supplemental needs trust. There's a lot of benefits to those options, but if a beneficiary would prefer to just get their inheritance in their own name, put it right into their own, personal checking account, that's completely up to them, and that's perfectly fine as well.
Does that happen after the 4 months have passed when you run the ad in the paper, correct?
Yes. So publishing that notice to creditors is one of the very first things that we do in the process. And the process of actual asset liquidation usually takes around 6 months, just kind of depending on what assets are in the trust. The things that usually take the longest are stuff like real estate. So if you have somebody who maybe passed away in like November, you might not get the house on the market till the spring. And then there's that whole process. So we say anywhere from 6 months to about a year is the average for administering a trust. Yes.
You got some tax returns that have to be filed and paid, and how do you go about filing? Do you have to wait till the end of the year to file the return? Because then you have to wait another 3 or 4 months if there's a refund coming.
Yep. So with the taxes, the first year that you're going to have to file an income tax return for the trust is whichever year you start liquidating assets in. So you'll be getting 1099s from the companies where you've liquidated the assets from. So if you have, for example, like investment accounts that you cash out, consolidate into the trust, that company would send you a 1099 for that. That would have to be included with your income tax return.
Like government pensions and Social Security. Can you get statements from them earlier in the year?
Before somebody's passed, you mean, or wait until the end of the tax year?
Once we make sure those payments stop, is there any way to get those statements before having to wait until February of next year?
I'm not sure about that. Do you have any idea, Terry?
Yeah, I don't know that you could get those earlier, but you usually can't file the income tax return until the forms are out.
Mm-hmm.
So like if they die January, February, you may have to wait till the end of the year to file that deceased person's last tax
return. Which means it's going to take more than a year to go through the liquidation process.
It very well could. You may have a good idea, like if they're getting, statements like with their retirement, how much is paid year to date, that sort of thing. You may ask an accountant about that. Are we looking at a refund? Are we looking at having to pay? Those sorts of things. So, and we are not accountants or financial advisors here. We know a lot about those areas, enough as I say to make us dangerous. But usually what it is you really need this issue to be discussed with, an accountant. But I don't know your answer, I'm sorry, on whether you get those statements early.
I knew the answer that I knew, and what you're saying is you don't know of any answer to the contrary.
Correct.
Knock out, maybe distribute the rest of it, whatever might be left.
That's what we see most often, because we might be ready to make those final distributions, and then you've got to wait almost a whole nother tax year. So, what we see trustees do a lot of times is try to get an estimate from the CPA, hold a certain amount back in the trust account, distribute the rest, and follow up in about a year. Yeah. Yes.
And this is just kind of a weird question. What if somebody died and their debt exceeded their assets? Are the kids responsible for that?
So this is going to be dependent on how the assets are all held at the time of your passing. So if your trust is properly funded or everything had a beneficiary, and you don't have anything going through probate, depending on the type of creditor, there's a good chance that, the trustee can get away with not having to satisfy those debts. It just really, really depends on how your assets are titled, who the beneficiaries are, and what type of creditor it is. Like Terri mentioned a little bit earlier, nursing homes are going to be the hardest to get away with not paying.
So if the nursing home was owed more than the assets in the trust, they can't come back on the beneficiary. Is that true? Or
with nursing homes, it's a little more complicated. I think with nursing homes, you might see a little bit more back and forth between the nursing home's attorney and maybe the attorney for the beneficiaries. Wouldn't you say, Terri? Yeah. Sometimes you can come to an agreement, a settlement, not maybe the full amount.
Right, but you are not personally responsible out of your own assets to pay the nursing home.
This was my.
Yeah. No, you're not personally responsible.
Assume that
No. So mom dies and she had $700 in her bank account and that was it. Right. There are, if you're going through probate, there are allowances for the children to get a certain dollar amount or the spouse, but otherwise before the creditors. But you are not personally responsible to pull out of your own pocket. So.
Yes.
Just curious, what are the mechanics of notifying creditors? The publication of that. How elaborate does that have to be? Is that an obituary posted in a local newspaper and don't worry about it? Or?
Yeah. So the question was what this notice to creditors process looks like. So there's a different newspaper that we use for each county. So for example, for somebody who was a resident of Kent County, we published the notice to creditors in the Rockford Squire. Why the Rockford Squire? Not sure, but it's an approved publication and that's the one we use. At that point, it is on the creditors to locate that notice and to follow up on it. So I can imagine that these companies have people where it is just their sole job is to scour through those notices and reach out. From that point, if we receive a bill, so at the beginning of this process, we'll ask the trustee to provide us with copies of any bills that they've gotten for the person who passed away. We respond to those creditors with a copy of the notice. That notifies them that it falls in their court. They need to file a statement and proof of claim. Once they've sent the statement and proof of claim to us, we say, thank you so much. Our answer is no. From there, their only option is to file a lawsuit to try to claim what, and other than nursing homes, in my 7 years here, I haven't seen it. I don't think Terry's seen it. Most creditors go away at that point. Once they see that you have a trust. The probate process is a little bit different, but at least in trust administration, that's typically how it goes.
Another separate shared trust question. I mean, the person that, so-called benefit from it actually isn't part of that being set up. So they reach that option. Now they're part of the trust. How do they more or less, lack of better words, dissolve that separate shared trust so they can use the assets, the money, whatever?
Sure. Yep. So the separate share trust. Once all of the money is in that separate share trust account, the beneficiary does have access at that point. So they can take money out of that account however they please. One of the other benefits that I have not touched on, just because it's a little more complicated, but one of the other benefits of that separate share trust is we set up a line of credit document for it that states that any money that the beneficiary is spending out of that account, they're just borrowing it. That way, at any point, 20 years down the road, if they wanted to, they could pay back up to the principal amount of their inheritance. And it's once again automatically protected, off the table for creditors, off the table for the asset test for Medicaid. So it's a nice financial tool for the beneficiary to keep in their back pocket.
Until the person passes away and then it's funded.
So this is for that separate share trust option where if a beneficiary wants to put their inheritance in that separate share trust, what I was saying was they can spend that money however they want. They can spend all of it. So say somebody inherited $100,000 and, 20 years down the road, they've spent that full $100,000. Suddenly they realize they need Medicaid and they're trying to, spend down their assets, trying to get qualified. You can only have $2,000 in cash, I think a house, a vehicle, and a prepaid funeral. So if, for instance, they had, $98,000 in their savings account, they could take that $98,000, put it back into a separate share trust account, automatically off the table for that Medicaid process. So, all right. So once we get to the very end of this trust administration timeline, we're making final distributions. So can't do that until the notice to creditors has expired. So at minimum, you have to wait that 4 months. Again, typically takes 6 to 9 months. It completely depends on what assets we're dealing with. At that point, we prepare an agreement and release document. I think Terry mentioned this at the beginning. And this just goes over the exact amount that each beneficiary is receiving. By signing that, they're agreeing to the amount that they're receiving and they're releasing the trustee from any liability. All right. Any other questions about trust before we move into if you don't have a trust? Yes.
Yes, I should ask a question. We set up the tax legacy trust.
Yes.
There's a son and a daughter and 2 grandchildren. And we have a stipulation that the grandchildren get a certain percentage. So we can take and distribute that to the grandchildren. My son would probably want his money, but my daughter wouldn't need it. So can he take his and then the rest of it stays in the tax legacy trust for my daughter?
So are you asking if your son could potentially bypass that separate share trust that's built into the legacy trust?
Yes.
Okay. So with those legacy trusts, those are a little bit more rigid than our standard, protection trust or revocable trust. The goal of those, is to kind of force those beneficiaries to use their inherited IRA as a income stream. We have found that if we absolutely need to, there can potentially be some loopholes where we can get, for instance, your son's share transferred to an inherited IRA in his name. And then from there, he could decide what to do with it. So the goal is to really make the beneficiary aware that their main option is that separate share trust. But the short answer is we found some ways around it if we need to.
The grandkids could get their money immediately.
Is that how your trust is set up?
Yeah. We set up the tax legacy trust.
Yep.
But we have a certain small percent going to grant.
Okay.
So they could get theirs at
immediately?
I believe so. That sounds right. Yeah.
How old are they? How old are the grandkids?
15 and 16.
Yeah, they're probably, depending on how much is there, they're probably too young to get it outright
Right now they are.
right now. And they've got a pending law. I've got to check and see if it passed for minors, increasing the amount that they can receive outside of a trust or even going through probate for direct distribution. The pending law is going up to $50,000. Right now, I think it's 5 or 10,000 that they can receive without having it in a conservatorship account or having it in a trust.
Well, we primarily have.
And that's a good use of it. But keeping in mind that when that money comes out, it's taxable.
Yeah, I was just looking at this, that's one of the exempt reasons to withdraw before 59 and a half, right? Is to just for education expenses.
I don't think that 59 and a half applies.
Okay.
Because we have this new law called the Secure Act. And beneficiaries can stretch it out over 10 years, but it's got to be taken in that 10-year time period. Spouses can roll over into a spousal rollover, and then you have, your own life expectancy. But now with the new laws, beneficiaries getting IRAs stretch out as 10 years.
So the money goes into tax legacy trust.
They
For
eventually
them to leave it there, but after 10 years, they get it.
Right, so the RMDs that, when you reach a certain age, you have to take, they don't have to. But within 10 years, it's gotta go out. The problem is that the Secure Act is a fairly new law. We have Secure Act 1, Secure Act 2. And the IRS has not written all their guidelines on whether you have to take it out at the end of 10 years or out over 10 years, because it might be beneficial to leave it into the 10 years, gain the income on it, and then take it out. But the act is
Do they ever decided it?
I don't think so, but I not the tax expert. David is our tax.
David was kind of tell kids to leave it in.
Yeah, he does, because he thinks it's best to leave it in, and yep, exactly. Okay.
So I just have one question.
Mhm.
So my aunt has a trust through you guys.
Mhm.
I am her trustee and I am the only beneficiary of
Okay.
everything. So would that still have to go through every single process too?
That's a great question. So when it comes to being the sole beneficiary, that can make the process a little bit less complicated. For instance, you don't have to put together a trust accounting because the only person you would have to deliver that to is yourself. You would still want to publish that notice to creditors. There's still updated documents that you'll need in order to conduct business on behalf of the trust. So one of the really important documents you'll need right away is an updated certificate of trust existence that shows that you are now the sole current acting trustee and you have the authority to conduct business on behalf of the trust, access all of the trust accounts, do everything that you have to do. Would you necessarily need to follow the entire full process? Not necessarily. You wouldn't have to worry about agreements and releases. You're the only beneficiary. Don't have to worry about doing an accounting of the trust. You're only accountable to yourself. Those are the main differences. Yep. Yes.
A question on, when you find your trust or whatever on your life insurance policies.
Yes.
You expect that those have been titled to the trust.
Yes.
How do the kids inherit that tax-free if it's to the trust? How's the trust get a tax-free investment?
So,
How do I get that tax-free?
So it's still tax-free, even when it comes to the trust. It's the same as any other account that you're going to liquidate. Typically you'd get 1099s from many other companies for the life insurance policy, specifically tax-free. In terms of how they get it, it's just a matter of completing the claim forms indicating that the trust is the beneficiary. If we're helping with the administration of the trust, we're usually the ones filling out all of the forms and we just, sign here, sign here. The check comes payable to the trust and it gets deposited into that new trust account that runs under the trust tax ID number.
insurance policy, and there's two beneficiaries, you want to put your kids, how do they get that?
So they get the money out of the trust account. So if the trust is the beneficiary, like I said, all of the money goes into this trust bank account. At the very end of the process, when the final distributions are made, that's when it goes to your two beneficiaries. As long as the people that you want your life insurance policy to go to are the same people named as the beneficiaries of your trust, that's who it goes to.
Why wouldn't you just leave it, why put the trust in and muddy up the water, then they just get it?
Well, one of the main reasons is so that they have these options like the separate share trust. If they were to just get it, and let's say they were receiving some sort of government benefits or going through a divorce, all of that money is on the table then for those. Or creditors, or if they have tax issues.
It's even protected from the IRS.
Yeah. So that's one of the main benefits of funneling it through a trust, is so that the beneficiaries have those options. Okay. Any other questions? Yes.
If it takes a year and a half or more to go through a trust and sell a house and so on, and if you are administering it, you have an estimate of how much you charge for that? And if you are managing the account, are you taking a portion of that? Like, for instance, a bank will, during that interim time, will collect like 1% of the income.
Yeah, so we operate on a billable basis. So we collect a non-refundable retainer if we're retained, and then we just charge by the hour. So it depends on how complicated the trust administration is. That non-refundable retainer right now is $5,000. For a standard trust administration, that's typically about what it's going to cost. It's not so much about how long it takes. It's more so about, how many, if you have 3 beneficiaries or 20, if you have 5 different accounts in your trust or 20, that's kind of what we're talking about when we talk about the price difference and how long it can take.
But the average is about 5,000.
Yep.
And as long as you're asking that question, as a trustee or personal representative, you can charge a fee. Is that on your list? Or?
No. So what you said about the bank. So we would not be managing those trust accounts for you. We walk you through the process of opening them, but you are the named trustee on those accounts. Exactly. So technically your trustee can charge fees for their time. And most trustees can charge anywhere from $25 to $30 an hour. And we let them know if they are interested in doing that, they should keep a log of their time and mileage and that sort of thing, so they can be paid and or reimbursed out of the trust.
So is there anything else, your upfront fee, and you said that usually for most of them does it, and any fee that the trustee bills for? And of course, and I named a funeral representative. In that, I said that she used to be paid travel and lodging expenses. But beyond that, is there anything else that you could think of that would?
In terms of expenses? Yeah. Not that I can think of. All these things that I've mentioned, like publishing the notice to creditors, that would all be something that would fall into that retainer that we're given. So no, I don't think so.
Okay. That gives me an idea.
Yeah. Yep.
You threw out the amount of $25 to $30. I mean, what's considered? That might be what you carry inside since years ago.
It's a reasonable amount.
So we know the judge.
The judge is somebody who defends it.
Yeah.
We know in Kent County, $25 to $35 roughly. Judge Murkowski, who used to be the only probate judge, we have 2 now. But that's what he pretty much approved. He did not, one time, I just have to share this. One time he said, I don't think it's right that we're paying the personal representative $25 an hour to clean out the house. You could get somebody to clean out a house for $10 or $15. And my response was, who?
Yeah, I
Yeah.
want that name. $5 an hour.
But it's not anywhere, any legal publication or anything, and it's usually county by county. You probably would get paid more in the Detroit area. If you are an accountant, you can get paid more because you're adding additional skills.
And so probably it's almost more important to log everything. you've
Absolutely.
done
Yes.
To justify.
Yes.
Exactly. What you did,
Yes.
what day it was, how many hours.
Yeah, I've certainly had trustees who, wanted to do $50 an hour. And I said, that's completely up to you. Just be prepared in the event that a beneficiary should contest this. You got to back up. Yep.
So mileage is also included
Yes.
in that, and they'll give you a book to keep track of everything.
Yep. Yep. Yes.
Once I pass and my sister becomes
Your trustee.
the trustee,
Mhm.
she contacts you on my demise. Is her first visit with you a free visit and you would tell her what needs to be done? And she can decide whether she wants to take the $5,000 off the top to pay your services and do that? Or you walk her through and tell her distinctly what needs to be done for them, step to step, for her to do it on her own if she chooses?
Yep. So during that initial meeting, we talk about everything that needs to be done in that particular instance. I have gone through in as much detail as possible, all those different steps, and then, let the trustee make an educated decision on whether or not to retain us to assist them. Sometimes we have trustees who instead choose to only retain us to prepare the updated documents. Like I mentioned a little bit ago, that updated certificate of trust. Each trust needs its own tax ID number, which we can get, those sorts of things. It really depends on how complicated the trust administration is going to be. We can give them a good idea of what it's going to look like, and then falls in their court. Yeah.
Who decides after, you're talking about receiving in that special trust or whatever, who decides at what that point, whether it goes into A, B, or C? Who decides that?
The beneficiary.
Okay.
The only way the beneficiary is not making that choice is if you, as the grantor of your trust, specify that one of your beneficiaries needs that supplemental needs trust, the special needs trust. That one, they don't have an option on. The only way that can be changed is if your trustee, so your sister, if she determined that it was no longer necessary for that beneficiary to have the supplemental needs trust, the trustee has that discretion, but the beneficiary can't decide that.
At what point do these other people, okay, that 2 kids and a couple of sisters or whatever, who contacts them and asks them what they want to do?
Your trustee. Yep. So one of the things that we do as a firm, once we've been retained to help with this trust administration process, we send a letter to each beneficiary. It gives them an idea of what this process is going to look like, how long it's going to take, the sorts of things that the trustee is going to be doing in the background, and we give them their options for their distribution in that initial letter. So they'll have some time to think about it and make their choice before it comes time to receive their inheritance.
In the event that the beneficiary is a minor, can the grantor determine who makes the decisions for the minor child?
Yes. So depending on the amount of money that they're receiving, we'll handle it a couple of different ways. Usually a minor will receive their share in a separate share trust, or if it makes more sense, sometimes we will just have their money managed by their parent and they manage it for them. We see that more frequently if a grandchild's getting a specific bequest of, maybe $5,000 or $10,000, mom or dad will just hold on to that for them, use it for their benefit.
6 figures.
Yeah, in that case, it would definitely be a separate share trust. Yep.
Thank you.
Yeah, you're welcome. All right. Yes.
Dumb question. So if my son comes to you and says, okay, I want you to administer the trust,
Mhm.
whatever, and he's the trustee,
Mhm.
does he have to pay you that retainer up front, or does it just come out of does he have to come up with the money? Or does it come out of the assets?
Typically, yes. We like to have something up front before we start doing any work. We have had circumstances where the money is just not there until the trustee can get access to the trust. Sometimes in those cases, we'll take, some sort of goodwill deposit, do enough work to get them access to an account so they can get some of the money and then get our payment. So we can work with people, but, as a general rule, we do like to get that retainer before we get started.
You verify that the money's there is in the account. And the trustee can't just give a $5,000 check. You can work with them.
Yes, yeah, we've done that. Yep. All right. So if you do not have a trust, you might have a will. And a will is basically instruction manual to the probate court of what a person's wishes are for after their passing. So a will does not avoid probate. It is just simply a list of instructions. If you pass away with no will, then the court has a predetermined list for how assets are distributed and for who handles the estate, who has priority. So in Michigan, the person who administers the will is known as a personal representative. You'll often hear that used interchangeably with the term executor, but here in Michigan, we use the term personal representative.
And you are the personal representative, the law firm?
No, the person
that we named is the person.
So you're going to be wearing two different hats. So if you have a trust and you have a will, it's probably the same person, but they're going to be a trustee and a personal representative. They're just called different things in a trust versus a will. Yep. But same job. They're administering the will. So the probate timeline is similar to the trust administration timeline. We have to start by filing an application with the court. Most commonly, that's going to be an application for an informal probate. Beneficiaries will receive a copy of the application and a testimony to identify the heirs. That's typically how they're going to find out that a will is being probated. And the beneficiaries don't need to do anything with the documents. The court requires that certain documents are served on the beneficiaries as the process goes on. So we have to mail those out each time. Again, you'll know that an estate has officially been opened if you receive a notice of appointment from the probate court. So if you're a beneficiary, you might get a notice indicating that somebody has been appointed as a personal representative. You would also be notified of any attorney fees that personal representative has paid. Again, you don't need to do anything. It is just a requirement by law that you're notified if you're a beneficiary. The same as in trust administration, in the event of opening probate, we publish notice to creditors. And again, creditors have 4 months after that date of publication to file a claim against the estate. After that, the claims are barred forever. Creditors who make claims are not guaranteed payment. This works a little bit differently in the case of a probate estate. These assets are not completely protected like they would be if they were in a trust. Instead, there are certain allowances and exemptions through the court. Certain people who have priority to receive the funds before creditors do, but some creditors may need to be paid depending on the situation. Yes.
If you have a trust, why do you need a will?
So if you have a trust, the majority of your assets are going to be funded into it, hopefully. If anything were to happen where something didn't get funded into your trust, if you opened an account later in life, forgot to update your trust, or for instance, like cars, certain things that can't be funded into a trust. An inheritance, yes. Yes, that's true. If you were to, how would you describe that? If you were to receive an inheritance from somebody else's estate and you were to pass away before receiving that inheritance, it would be owed to your estate. And rather than it going through that predetermined list of individuals based on what who the court says should inherit it, you have this will that directs who it should go to. That might differ from what the Michigan intestate laws state.
So if we created a trust with the, does that also include the will?
Yes, yep. And what the will says, if you have it through us, is that everything goes to your trust, which is important because if we were to need to open probate for any assets, according to the will, it would go to your trust. So once it's been probated, that money would go into a trust account, and then it could be distributed in accordance with what we talked about earlier. Your beneficiaries would still have the options of the separate shared trust if they wanted. Yes.
This is money like with Fidelity Bank guys, beneficiaries are paid directly, and none of this is applicable.
As long as you have a direct named beneficiary, whether that's a trust or an individual, it won't go to probate.
A will would suffice for that.
As long as you, have individual beneficiaries named.
One of the risks is if you've got individual beneficiaries named and something happens to them and they die, that's where you're gonna have problems because you might not have any beneficiaries.
The instructions are that happens that percent is let people.
Yeah, contingent.
You can have a trust, taking care, it's funded properly, but the person that's with the meeting to say there's one thing that he or she forgot. How is it come find out what this is in the trust?
So it's a matter of getting access to it. So let's just say you had to the account. So your trustee, when they're, trying to get access to all your accounts, everything's in the trust. So they're consolidating everything and they come across this, let's say it's an investment account. It's in your name, not the name of the trust. They have no authority to access that account. They're a trustee, but if that account is not in the name of their trust, they can't access it. So if it has over $28,000 in it, right now that's the threshold.
That's where they notify.
If they want to get access to it, they need to get letters of authority from the court, your trustee or whomever's trying to access it.
That was outside the trust.
Yeah. If they look at it and say, I don't need the money, nobody's going to notify the probate court, but they want to access that money.
Again, you set up a trust, both sides think it's really good. How does the probate court know, hey, we think there's something, whatever. I don't know if that's right.
They don't.
They don't.
You wait for your personal representative or your trustee to notify them. But Heather mentioned they would notify.
So that
why would you notify them?
To get access.
That's
to
the
that
only way
money.
you can get the
Yeah.
Yeah, and there is an affidavit procedure that, if all things line up correctly, this year, if you died, 28,000 can pass according to the affidavit if there's no other probate assets.
And that would kind of be part of the so-called informal probate.
So that would be considered a small estate. Yeah. So we see that fairly often when we're administering a trust. We might come across maybe a small account, or sometimes people get refund checks that are made out in the name of the decedent. You can't cash them, but we can use that affidavit procedure as long as the total amount of non-trust assets falls under that threshold. So for 2024, it's 28,000. A few years ago, it was like 24,000. Just depends. Yep. You're welcome. Another one of the notices that we do in the probate portion is a notice to the friend of the court. So when assets are being probated, we need to notify the friend of the court. We notify them of the decedent's passing, and then we also give them the names of the beneficiaries. Because if any of those beneficiaries owes money to the friend of the court, typically for child support, their inheritance can be garnished by the friend of the court. All right, so in probate, the next few steps are very similar to what we do in the administration of a trust. We determine all of the estate inventory, so all of the accounts that are going to be going through the probate court. The difference is we need to file this inventory with the court. There is also a fee that's determined by the court based on the value of the probate assets. So the higher value of assets that you have being probated, the higher the fee is going to be that needs to be paid to the court. The inventory only includes assets that were in the individual's name alone. So if there is a married couple, husband's name is on the account, he's still living, those automatically go to him, do not need to be probated. Asset liquidation looks fairly similar to that of trust administration. Once a personal representative has been appointed, the court issues what's called letters of authority. And that is what gives them the access to those accounts, like you had asked about. Similar to in trust administration, we give you a certificate of trust. These letters of authority work the same way. You bring them to the bank, they would see that you have authority to access that account, and you would gain access. Instead of consolidating all of the funds into a trust bank account, in probate, you consolidate all of the funds into an estate bank account. So my estate bank account would be the estate of Heather Zinsky. It would run under its own separate tax ID number. All of the money gets deposited into there. You keep an estate accounting going. You need one for every year that the estate is opened, and it's a requirement that is served on the beneficiaries each year, showing everything that goes into that estate account and everything that comes out. Again, income is typically in the form of interest, refund checks, life insurance payouts, expenses, things such as utilities, funeral bills, home insurance. When it comes time to make final distributions, we need to wait until that notice to creditors expires. And again, we would follow the same process that we do with the administration of a trust. We would have each beneficiary sign off agreeing to the amount that they're receiving from the estate and releasing the personal representative from any liability. At the end of the probate process, we submit a sworn statement to close. The personal representative would sign off on that, and it gets sent to the court. And after 28 days, as long as the court doesn't receive any sort of objections from the beneficiaries, they will close out probate. And that can only happen after a minimum of 6 months that estate remains open. Every year that an estate remains open, we need to file what's called a notice of continued administration, where we just tell the court why it's still open. And it basically is still liquidating assets, as long as we keep the court informed. And that is everything I have for today.
Is there any chance you have a printout of everything you had on the screen?
I don't have a printout, but I can probably. Yeah, I don't see why not. Yeah, we were able to. I think it actually might even be available online. If you want to give me email addresses, I can make sure we send a copy of the PowerPoint. Yeah, that's fine. Yeah, of course.
Probably varies. How many death certificates typically do you recommend ordering?
So these days, most places pick up a copy. So I would say, to be safe, get like 3. And as much as possible, just have people take copies. We usually take 1 original, and at the end of the process, if we still have it, we still have it. So
it seems like your raised stamp copies been requested. Is that done?
I think in the last few years we've gotten a lot more comfortable with the electronic processing, so we don't see as much of that.
But if you have more than one piece of real estate in different counties, usually the register needs what's that certified death certificate, right?
Mm-hmm.
If that is
when recording deeds, I just upload a copy and record online. Yeah, and I haven't done non-online recording in years and years, so most counties do online recording.
If you happen to be a co-trustee,
mm-hmm.
Any action taken have to have. We're now in a space where the funder of trust is not able to make decisions, so we've got 2 programs.
It depends on what the trust says. So ideally, the trust would have a provision that says that you can act without without both of you signing off or being there. That's ideal. We don't love to see co-trustees. One of the big reasons is when it comes to like the claim forms for different companies, they're just not set up for co-trustees, and it makes it just more time-consuming, more complicated. And then, of course, if there is ever an issue with co-trustees getting along, that's a whole other layer to it.
Yeah, and our attorney back there, Chris, is smiling and laughing at me during this comment because he's had to deal with some of the banks that say that both must sign, even if there's language in that says one day. And so we've been kind of going running around with the bank.
Okay,
oh, you're fine.
Yeah. Is there a limitation, such as periods on expenditures? Okay, so expenses that are done while they're still alive and we're managing that. Can there be things that are don't, like if somebody gives to grandchildren, how much leeway does an administrator?
I think what you're talking about is Medicaid.
No. We're not trying to. We're not trying to spend it out. Trying to distribute to. So
how much discretion does a trustee have to distribute, not necessarily according to what the trust says?
It's just like the grandchild, like
yeah, that's
an IRS thing.
Yeah, there is a look back though if they would have to apply. Medicaid looks back after 5 years. Yeah, depending on the amount, you might actually know.
Yeah,
it's what they give you.
So even if you had a trust,
I will send that over to you.
still limited by the time.
Yes, that's perfect. Thank you. You're welcome. Okay.
But if you have one in a protection trust, for those assets that are in there 5 years, so then your divestment rate is back. So you have to want to get it out of there.
Right. We have some questions from the Zoom attendees. Please feel free. I won't be offended. Okay. The question was, do all heirs need to be notified of life insurance policy if they are not a named beneficiary of that policy? The answer is no. The only person who needs to worry about that policy is the named beneficiary. If the trust is the named beneficiary, then beneficiaries of the trust will get notified.
Are you and other costs of administration, like expenses, accounting expenses, for the trust accounts, does that have to be specified in the body of the trust?
So the question was, are attorney fees considered expenses of the trust? In other words, can the trustee pay for those out of the trust account? Yes, those are like expenses. It does not have to specifically say in the trust, although I'm sure in every instance it does say in the trust. The attorney can be paid in trust funds. That will show up on the trust counting, so all of the beneficiaries will see that's where some of the trust money went to.
The distribution time on the will was what?
For how long it typically takes?
No, not until time.
6 months. The estate has to remain open.
Why is there a difference on that?
4 months. So the court still applies. So 4 months in both cases, but for probate, the court specifically requires that the account stay open for 6 months. If that's separate from the that's 4 months for both. Yeah. Any other?
Is it possible you have to file both personal and estate taxes in the same year?
Is it possible you would have to file personal and estate taxes in the same year? Yes. So for a decedent, you'll file their final personal taxes. In addition to that, you will be filing potentially estate taxes, potentially trust income tax return.
The last question we have is how often do you have to report accounting? For example, will it be quarterly or will there be, there will be many beneficiaries or large families?
So the question was, how frequently does the trust or estate accounting need to be reported to beneficiaries? Typically, that needs to be reported on an annual basis. If you want to provide more updates, that's completely within your discretion as a trustee, but at minimum, it should be provided each year around the same time.
I have a question.
Yes.
On your, when you sell your home, like, now you got another home. And what happens when they sell the mortgage? How does that go?
Sure, yeah.
When a person, so you're talking about that, it used to be a once in a lifetime exemption. It's now every 2 years.
Oh, okay. So
but when a person dies, you get for capital gains tax. This is what we're talking about. You get a step up in the basis to date of death value. The basis is what I always use an example. I'm going to get my house for $10,000. It's now worth $100,000, and we're going to sell it. Are we going to pay tax on that $90,000? No, you're going to take that property and whatever it's worth on the date of death. And so then if you sold it more than date of death, yeah, there's going to be capital gains. But most people sell the house within a year of date of death. I would say if it's an arm's transaction, there's probably no capital gains there. Because fair market value has a date of death. The difference between that and what you sell it for, and of course, if you sell it, you got realtor fees and some of that other stuff that can be deducted. And as I said, I'm not an accountant, but I have worked with this quite a bit with regard to the step up in basis. And so, yeah, usually when it's sold, there's no capital gains, but you always want to check with an accountant to make sure, depending on the person that's sold.
you do both that.
Mm-hmm. For you individually.
Yeah, and my wife, and then that's where the sale will come up.
You also buy the trust for probate estate. And it files a 1041, but probably gives too much. But that's the equivalent of an individual's 1040, but it's a fiduciary return. It does not get all the deductions and exceptions like the personal taxes do and the tax rates. Jump into a compressed tax bracket much sooner. But that's where if there was capital gain or loss, it would be reported on that 1041. Also, with our trust, they are passed through or conduit trust, so that gets passed through the beneficiary, so it's at the individual's weight on a K1. But that's probably too much for you.
Personal tax and step up, and then
if it's gifting, though, let's say your house, your life statement for your wife, and they just from your wife too. So whatever her name is, she does not get the step up in basis.
And then when she sells it, she'll be huge.
whatever you want to tax basis.
Right, correct. She takes your basis.
It's not when I get it.
Email?
No, but if she doesn't get it until you die.
Yeah, do you want to write it on here? Send it to you. All right, got it. You're welcome. Have a good day. You're very welcome. I'm going to give this back. Did you have any other questions? Okay.
Excellent. Seriously.
Your website.